It's a few minutes after 2. So, first, I'll just introduce us briefly. My name is Jennifer Preston. I work for Canadian Friends Service Committee, which is the justice body of the Quakers in Canada. This is Joffe, my colleague, who works as legal counsel for the Grand Council of Crees, the UESG, the Cree. This is the Cree political body in Northern Quebec. And Paul and I have had the luxury of working with the UN Declaration for decades at this point. And we were both involved, Paul longer than I was, in the standard setting processes of the United Nations that developed the Declaration. And then we were both really active in the political period in negotiating with states to have the Declaration adopted. And we had I met April at a conference last spring at the University of Waterloo where I was talking about the history of the Declaration. She had said, will you come to our conference because it's really interesting to understand where the Declaration came from. So that's how we came to be here today. So we're really happy to be here with you, and I want to acknowledge that we're privileged to be working today on the territory of the Tsilhqot'in Nation. And I also want to acknowledge our elder who started us in a good way this morning and at lunch, and I also wanted to acknowledge, I think, your grandchild, the newborn baby, who also is, I think, helping us be in a good way. Looking at that baby, both last night and today, reminded me when my daughter was born, and she's now an adult, but when she was born, somebody said to me, when a new baby comes, it's the Creator's reminder that the world should go on. So thank you for your baby for inspiring me. So we have 2 presentations this afternoon. We're doing this first one, which is on the UN Declaration, and then we're doing one after the break on FPIC and law. So in this first one on the Declaration, we won't go into FPIC and the UN Declaration because that is what we will be doing in the second presentation. But I wanted to begin. Can everybody hear me okay? Okay. I just know there's a noisy fan there. Wave at us if you can't hear us in the back. And I know that you all got a copy of this booklet in your conference bag. The booklet is put out by the Coalition for the Human Rights of Indigenous Peoples. Both of us have been very active in that coalition. It's a large group of organizations, Indigenous political organizations at the federal, regional, and local level, as well as many independent Indigenous experts that have done UN-based work for a long time. And we put this booklet out the first time in 2007 after the adoption of the Declaration, because we really felt like for people to know the Declaration, it had to be widely available. And so we produced this booklet version of it. And so far we've distributed about 500,000 copies of this in Canada. I had somebody from the Canadian Human Rights Commission call me up one day and said, Jennifer, the UN Declaration on the Rights of Indigenous Peoples is the best known human rights instrument in Canada, and it's because of those booklets. So, hooray for booklets. So on the screen we have a paragraph from the Declaration, and I would say in your booklet you'll notice the Declaration consists of 46 articles and then 24 preambular paragraphs. The way that the UN produces instruments, they number their articles, they don't number their preambular paragraphs. But Paul likes to always remind people it is useful to number your preambular paragraphs so that if you're making reference to it, it's easy to find. So on the screen, we have the preambular paragraph number 7. And the reason we wanted to start with this is I think that this paragraph speaks to the reason that Indigenous representatives spent so much time at the United Nations fighting for this declaration. And it speaks to recognizing the urgent need to respect and promote inherent rights of Indigenous peoples. And that's a really important place to start. Inherent rights means pre-existing rights. Indigenous peoples have inherent rights because they are Indigenous peoples. These rights exist long before Canada existed. And it's also important to know what's in the Declaration, no new rights were created. So Indigenous peoples have these rights and had these rights and will continue to have these rights. And what the Declaration does, it affirms them, it lays them out. And so it's telling us this in the preamble, and that these rights come from the political, economic, and social structures, as well as from Indigenous peoples' cultures, spiritual traditions, histories, and philosophies, especially their rights to lands, territories, and resources. So just to give you a sense of what we're going to run through in this presentation, we're going to look at the background. We're also going to look at the role of international human rights law in Canada and the legal status of the Declaration. And then we'll talk a little bit about reconciliation because, of course, since the time of the Declaration coming about, we have the work of the Truth and Reconciliation Commission. And then finally, we'll look at implementation and how it can be used at the community level. So to start with the background, the Declaration took more than 2 decades to develop, which makes it the most discussed instrument in the history of the United Nations. And one of the reasons that it took so long to do this work is because of one of the other unique features, which was the role of Indigenous peoples in developing the instrument. So the UN, at its core, is really a club of governments. It's an exclusive club of nation states around the world. But in the late 1970s, Indigenous peoples literally insisted, and they sort of pushed down those barriers, and a space was created for Indigenous peoples to come and begin this work of establishing an instrument that spoke to their rights. And what happened in the process of developing the Declaration, at a particular point, there was 2 different working groups, and in the second working group, because states have the status of the UN and Indigenous peoples did not, it seemed ludicrous that states would be negotiating what Indigenous people's rights were looking like while Indigenous representatives were sitting at the back of the room. And so it was agreed, because Indigenous peoples insisted, that the Indigenous voices would have hold the same weight as the state voices. And the way they were able to do this is they played with the UN rules, and they said, these will be informal sessions. So for the next close to 10 years, those meetings were considered informal, which meant that UN rules didn't apply. So it meant that Indigenous people's voices held the same status that government voices held. And what that also meant, and what states agreed to, was the UN likes to do everything by consensus. Consensus included Indigenous people's consent. So that's why the 2 decades, because governments weren't allowed to just run roughshod and put whatever they wanted in this declaration. So Indigenous peoples spent that time working with states to develop a human rights instrument that met both Indigenous people's needs and that nation states were going to agree to. And that's really important. It's a method of work that Indigenous peoples created at the UN, and it has not been repeated since. And we don't see that playing out necessarily in domestic environments either. But it's an important method of work, and there is precedence for it. So we don't have time to go through and there's many stories of how we got to the point of having the Declaration. But we're not going to go through all of that. Enough to say that in June 2006, after all these negotiations, a consensus was achieved by the states and the Indigenous representatives. And that went forward to the Human Rights Council. The UN had been doing restructuring, so this was actually the very first meeting of this reconstituted Human Rights Council. And the 2 states voted against it. It was Canada and the Russian Federation. However, it's obviously that's still a win. So then it goes forward to the General Assembly. And the way the UN works, usually if something has been adopted at the Council and it goes to the General Assembly, it's not a rubber stamp, but it's assumed that once you've gone through the one process, it's just going to go through. But it didn't. And that's because that some states, including Canada, lobbied other states really hard to try and create a diversion in essence. So what happened, instead of it being adopted that fall in 2006, the African group of states who really hadn't been involved in the negotiations very much, by choice, said, oh, well, we weren't really involved, and so we need to know what this means, and we need to take some time to learn about this. And so the UN is essentially granted a pause. So for almost a year, they said that this has to be concluded before this session of the General Assembly is over, which would have been September of 2017. So we went in, and this is now in New York. We moved from Geneva to New York. And New York is a very political atmosphere. And it's not about human rights. Geneva is a human rights environment. New York is very politicized. And this is where Paul and I worked that year. And it was excruciating. There was no process where Indigenous peoples had the same standing that states had. There was not even processes where states were necessarily engaging with Indigenous peoples in any kind of respectful manner. And so there was a real possibility that in fact the whole thing would just go down in flames. But because of a group of member states working with Indigenous leaders, a lot of pressure was put on to ensure that in fact it was not lost. And to make a fairly long story short, at the end of that year, there were 9 amendments to the text that had been agreed upon in Geneva. And Indigenous peoples were willing to take those amendments. And the states that were supporting Indigenous peoples said, if you don't agree with an amended text, we won't go forward, it will stop. But it was also, I think, really a now or never moment in time, and everyone knew that. And so it was decided that those 9 amendments, some of them, they weren't desired, some of them were really neutral, some of them perhaps limited text that was there before, and actually a couple of them may have improved the declaration. But it was agreed that if the declaration would go forward. So it was adopted on September 13th of 2007. And this is what that day looked like. So we're in the General Assembly Hall here, and which is the grandest hall in the UN. Up on the screen you have the President of the General Assembly, and she's on that podium, and you can see her, she's looking up at the 2 screens that are beside her where you see all the green lights. So what that is those are the names of all the nation states. And when they call a vote in the General Assembly, the way that it works is each state has their desk, you can see their desks at the front of the photo, and they have buttons, green, red, yellow. So when a vote is called on any resolution, they just press the button they want. And then their state goes up on the screen with the color. And we really, because there was so much political shenanigans, for lack of a better word, we really weren't sure what was going to happen. So the vote gets called, and there's a sea of green goes up. So 144 states voted in favor, 4 were opposed, and 11 abstained. So the 4 that opposed were Canada, United States, Australia, and New Zealand. All 4 of those states have now reversed their opinions. And the United States was the last to do that. Canada reversed its opinion in November of 2010 under the Harper administration. We believe that the reason they reversed their opinion is because Barack Obama had just been elected, and everyone knew that he was going to reverse the US position. And Canada didn't want to be the last state in the world that was opposing human rights for Indigenous peoples. So begrudgingly, the previous federal administration issued a press release on a Friday afternoon to their website that said, you know, we can now support the UN Declaration on the Rights of Indigenous Peoples. So that was the story of that. The current federal administration, we'll get into this later, has further affirmed a much more positive position on the UN Declaration. The fact that those 4 no's had changed their positions makes it a consensus instrument, and in international law that gives it greater legal weight. So there's no state in the world that opposes this instrument, and that's important. And so just a tiny bit more background, and the reason that this work was done. There's probably the number that is often used is 370 million, but people are now starting to use the number 400 million Indigenous people in over 70 countries in the world. And around the world, it's widely understood that Indigenous peoples suffer from dispossession from their lands, marginalization, and are widely discriminated against. And so it was understood that there was a void in the international human rights system because Indigenous peoples were being so marginalized on a global scale. And this instrument was an answer to that. There are other international law instruments that address Indigenous peoples' rights, but this is the most comprehensive instrument for Indigenous peoples. And it elaborates on a whole variety of rights, including economic, social, cultural, political, environmental, and spiritual rights. It has at this point been reaffirmed by consensus at least 8 times, which again adds to its legal weight and strengthens its legal position. In 2014, the United Nations held a World Conference on Indigenous Peoples. Whenever there's a World Conference, there's an outcome document, and in that outcome document, This declaration was also further reaffirmed by consensus, and that obviously includes Canada. Okay, so now I'm going to switch over to Paul.
So tell me if you can hear me. I don't have a strong voice like Jennifer. So let's turn briefly to the role of international human rights law in Canada. And in regard to the importance of international norms in the Canadian context, former Chief Justice Beverly McLaughlin of the Supreme Court of Canada affirmed in 2002, and you see it on the slide, Aboriginal rights from the beginning have been shaped by international concepts. Canada cannot ignore new international norms, and Aboriginal rights are an international matter. And from the outset, it's important to underline that Indigenous peoples' rights are human rights, and that's very important. To date, I can't say that the Supreme Court of Canada has addressed Indigenous rights as human rights. The lower courts have begun to do so. And Indigenous peoples' rights have been addressed in the international human rights system now for more than 35 years, and this includes both the collective and individual rights of Indigenous peoples. So in this 1987 decision, you have former Chief Justice Brian Dixon of the Supreme Court of Canada, and he ruled that declarations and other international human rights instruments are, and it's at the bottom of the slide, relevant and persuasive sources for interpretation of the Canadian Charter's provisions. So if international declarations are used to interpret the human rights in the Canadian Charter, which is Part 1 of the Constitution Act 1982, then the same must be true for Indigenous peoples' human rights in Part 2 of the same Constitution Act, Section 35. Now, in 2008, just to give you another opinion, the Canadian Human Rights Commission highlighted in its report at the time that human rights have a dual nature. Both collective and individual human rights must be protected. And the challenge is to find an appropriate way to ensure respect for both types of rights without diminishing either. Now, some of you may remember that James Anaya was a special rapporteur on the rights of Indigenous peoples. He visited Canada, I think, October of 2013, and he confirmed in 2010 that the UN Declaration is not binding in the same manner as international treaties, but it does, however, have legal effects, and it's not merely aspirational, as the former Prime Minister Harper used to claim. And Anaya adds right at the bottom of that quote, says, the Declaration is grounded in fundamental human rights principles such as non-discrimination, self-determination, and cultural integrity. Now, in an authoritative book on the Charter of the United Nations, and this is a huge book, it's 2 volumes, and each one is about this size. The 2 authors that you see at the bottom of the slide indicate that the term declaration is used by the General Assembly for resolutions which claim to express political or legal principles of particular importance. And in this case, I'm going to mention it's really legal importance here for the declaration. And what they say, the authors, they say examples of the most important declarations which have attained a quasi-legislative function. That means it helps in establishing legal rules, quasi-legislative, are the Universal Declaration of Human Rights of the 10 December 1948, which was the first international human rights instrument adopted by the United Nations, and the UN Declaration. So it is regarded as having important status, legal status in international law. Now again, the declaration is not binding in the same manner as international treaties, but it has diverse legal effects, and we've just mentioned a few here. First, governments and others may use the declaration for law, policy development, and decision-making. And this would, of course, include indigenous governments and other indigenous institutions. Canadian courts may and do use the declaration to interpret indigenous peoples' rights and related crown obligations. And also, international treaty bodies are using the UN Declaration to interpret other international human rights instruments, usually treaties. So it does have legal effect. Now, in 2012, the Federal Court of Canada ruled that the UN Declaration and other international human rights instruments, such as the Convention on the Right of the Child, may be used to interpret domestic human rights law. And then in February 2018, the Canadian Human Rights Doctrine ruled that of particular significance, especially in this case, is the UN Declaration. So as we can see from these cases, the UN Declaration has legal effects and is not merely aspirational. Now, Canada's Constitution is subject to the rule of progressive interpretation, because you can't just change a Constitution. When the telephone came into being, they didn't say, okay, can we get together an amendment to change the Constitution? The courts just have to use progressive interpretation to figure out how the existing Constitution includes the telephone and who has jurisdiction. So the court has referred to this rule of the progressive interpretation as the living tree doctrine in Canada. And we have here two quotes of the living tree doctrine. In 1984, the Supreme Court ruled that a constitution must be capable of growth and development over time to meet new social, political, and historical realities often unimagined by its framers. And the UN Declaration is such a new social, political, and I would add legal reality unimagined by the original drafters of the Canadian Constitution. And in the bottom quote, in 2004, the Supreme Court of Canada confirmed that concepts in Canada's Constitution cannot be frozen, and the rule of progressive interpretation must be applied to the realities of modern life. And in our view, these realities definitely include the UN Declaration.
So just to speak a little bit more to the significance, and at the end of the presentation we do go into implementation, so I won't go into that here, but just to draw your attention to a few things. On the screen, we have two articles from the Declaration, Article 38 and Article 43. And in Article 38, the reason we're sharing this is also particularly to the theme of this conference. This is the minimum standard in the Declaration. So in the Declaration, the minimum standard isn't that there's a duty to consult. In the Declaration, the minimum standard is consultation and cooperation, which is a higher standard than just consultation, because cooperation has a consensual element to it. And the example that I'll give you is if Paul and I are cooperating on preparing a presentation and we don't agree about it, well, how are we going to do that presentation? So if you are cooperating, there's a consensual element there. So it's a higher standard than just consultation. So that's the minimum standard in the Declaration. And then Article 43 talks about that the rights affirmed in the Declaration are the minimum standards for survival, dignity, and well-being of Indigenous peoples. So the UN Declaration is seen as the floor, not the ceiling, when it comes to Indigenous rights. And really, what we see, obviously in this country and in other countries, is the need for a paradigm shift. Because we have to move to, if the Declaration is to fulfill its purpose for the survival, dignity, and well-being of Indigenous peoples, we have to move away from the colonial model that we're currently stuck in, and moving away from a colonial model into a model that's respecting Indigenous peoples' human rights. And then this has a slide, we have the provision paragraph 3 from Article 46. And this is the final article in the Declaration. The reason we brought this up is that human rights are generally relative rather than being absolute. And they have to be balanced, so that the rights of all have to be balanced with each other. And my human rights don't trump Paul's human rights. And so if they come into conflict with one another, we have to figure out the balance. The only right in the Declaration that is an absolute right is that Indigenous peoples have the right not to be subject to genocide. And that is an absolute right in international law. So, but the other thing about this is mentioning the principles of justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith. These are core principles in both the Canadian and international legal systems. And so that's how the Declaration is to be interpreted. And going a little bit further on the concept of good governance, the second part of that slide has a quote from the Office of the High Commissioner for Human Rights, and that good governance has to include respecting human rights. So, specifically in Canada, good governance has to include respecting Indigenous peoples' human rights. And in terms of using the Declaration, well, as I said, we'll go into implementation at the end, but just some ideas about how the significance of it in terms of the wide varieties of ways that it can be used. And it can be used, obviously, consistent with Indigenous peoples' own sovereignty, governance, and laws. And so implementation of the Declaration will look different in different places because it has to be used through Indigenous peoples' own worldviews. There's not one way to look at the Declaration or to interpret the provisions. It has to be taken into the specific context that Indigenous peoples are living and working in and used in their own governance and laws. The other thing the Declaration can do is, and the Elder mentioned today about an empty box, Section 35 being an empty box, and that's obviously been a big concern since Section 35 went into the Constitution. And so the Declaration can be seen as filling up that box. And in fact, even Minister Carolyn Bennett had said at the United Nations, Section 35 is now a full box of rights, and understanding that that's what the Declaration can do. The Declaration can fill in gaps with treaties and other agreements, and particularly that can be useful for the numbered treaties that have much less detail than the modern land claim treaties have. And the Declaration can provide that detail. It can guide policy development and negotiations and litigation. And really, for where we are now, First Nations interests need to transcend domestic law. Domestic law is rather a box. And transcending that box of domestic law, the UN Declaration is a fantastic tool to be able to transcend that box. Okay, now Paul's going to talk about reconciliation.
Now, before I start, I do want to mention one other article that goes to Jennifer's presentation. It's the second preamble and paragraph. And it indicates that Indigenous peoples are equal to all other peoples, while recognizing the right of all peoples to be different, to be considered different, and respected as such. So if you're a Ojibwe, you don't have to be like Haudenosaunee or vice versa. You can be yourselves, and therefore you can interpret this whole declaration from your own perspectives and traditions and culture. And that's really important. So the declaration can be extremely flexible in terms of accommodating you. We didn't want to create a human rights instrument that would make you assimilate yourselves or change in ways that you don't want to change. So I'm just mentioning that article. So let's consider now the UN Declaration as the framework for reconciliation. And in July 2008, the UN Secretary General emphasized that the Declaration is a visionary step towards addressing the human rights of Indigenous peoples. It sets out a framework to build or rebuild state-Indigenous relationships and, as you see at the bottom of the slide, promote reconciliation and ensure that the past is not repeated. Now, in Call to Action 43, the Truth and Reconciliation Commission calls on all levels of government, from federal, provincial, territorial, and municipal governments, to implement the UN Declaration as the framework for reconciliation. Therefore, the TRC calls to action are inseparably linked to the UN Declaration. So you can't have someone say, a government or whatever, say, well, we fully support the TRC calls to action, but we don't support the UN Declaration. And also, the UN Declaration is cited explicitly in 16 different calls to action of the TRC. Now, at the bottom of the slide in Call to Action 44, the TRC calls on the Government of Canada to develop a national action plan and other measures to achieve the goals of the UN Declaration. And after we'll mention Bill C-262, which is a bill by Romeo Saganash, a Cree member of Parliament, to implement the UN Declaration. And in the 2015 report of the TRC, it emphasized that reconciliation, because we often wonder, what does reconciliation mean? Well, they described it as, it's about establishing and maintaining a mutually respectful relationship between Aboriginal and non-Aboriginal peoples. And it requires 4 key elements. You see it on the slide. There has to be awareness of the past, acknowledgement of the harm that has been inflicted, atonement for the causes, and action to change behavior. Now, in Tsilhqot'in Nation versus British Columbia in 2004, the Supreme Court of Canada emphasized that reconciliation is not a final remedy, it's not a point in time. Rather, it's a process flowing from rights guaranteed by Section 35 and the Crown's duty of honorable dealing. And then in Tsilhqot'in Nation, which was an Aboriginal title case I'll discuss later, in 2014, the Supreme Court of Canada highlighted that what is at stake here is nothing less than justice for the Aboriginal group and its future generations, and reconciliation between the group and broader society. You know, it's worth noting, just to compare Canadian law and international law, that the expert mechanism, UN expert mechanism on the rights of Indigenous peoples, which also includes Indigenous experts, and it's in Geneva. It concluded in 2014 that the UN Declaration constitutes a principled framework for justice, reconciliation, healing, and peace. So there are some parallels in what the Supreme Court said and what MREP was saying, the expert mechanism.
So then, just a few slides on implementation. And I think that one of the pieces that's important is, you know, Indigenous leaders and representatives from around the world didn't travel to Geneva for more than 20 years to achieve this declaration so that it could be in the library at the UN, right? I mean, if it doesn't have meaning in communities, then it's useless. So it has to have an impact for Indigenous peoples on the ground. I think that it's useful to have a word on where is Canada on the UN Declaration. So that I mentioned the endorsement in 2010. The current administration has made enormous political commitments, including, we have here the Minister Bennett speaking on behalf of Canada at the United Nations, that Canada is a full supporter without qualification. So in theory, we have a federal government that throws its full support behind the UN Declaration. And as Paul mentioned, we have Bill C-262, which is a private member's bill introduced by Romeo Saganash, and it went through the House last year. It's now at the Senate. It's being led at the Senate by Senator Murray Sinclair, the chair of the Truth and Reconciliation Commission. We are hopeful that it will be dealt with by the Senate fairly quickly, because we certainly don't want to get caught up in a political timetable with an election in a year. So we're hoping that it gets pushed quickly through the Senate and becomes law. And this, although it's a private member's bill, and private member's bill are a little bit different than government legislation, it does have the support of the federal government. So even though the federal government, there's plenty of places we could point and criticize about their action not living up to their political commitments, they have supported this bill. And when this bill becomes law, one of the things it does is it creates accountability for implementation of the Declaration in Canada. And I think that that's very important. And it also, here's some of the elements of 262. So it repudiates the doctrine of discovery. It also repudiates colonialism. And those are two very important things to have in the law in Canada. We don't have a law in Canada that repudiates colonialism, and 262 will do that. It affirms that the Declaration is an international human rights instrument with application in Canadian law. So no more can Indigenous peoples, if they are in litigation, in situations of litigation, and they're using the Declaration as a tool, they can't get a result where someone is saying, oh, it's only aspirational, because it confirms that it has application in Canadian law. And it also calls for collaborative processes, one, to ensure that the laws of Canada are consistent with the Declaration, and two, to develop a national action plan, as Paul mentioned, and that achieves an objective of the TRC. And finally, the legislation also calls for annual reporting on progress on implementing the Declaration. So this is an important piece of legislation. We've been working on this a lot in the last year, and we're really hopeful that, in fact, sometime in the next several months, this will become law. So Indigenous peoples can use the Declaration in different ways, and it can be as a tool. I mean, it can be a tool in litigation, it can be a tool in different ways of nation building. It can be, and this is with or without legislation, and this is with or without a government that supports it. Indigenous peoples have been implementing this instrument since the day it was adopted at the UN, or even before, all over the world, whether or not their governments are engaging with that. And so part of that is exploring meaning in your own context. And as I said, one of the reasons we produce the booklets is the first step to implementation is for people to know what it is. So I think the first step to implement the Declaration is to read it. And to see how it's useful to you. You know, what are things that your community is working on, and there's provisions in the Declaration that kind of assist and support that work and uphold that work. And people need to know that it exists. You know, distributing copies of it at the community level is very important. Translating it into Indigenous languages is important, and it's been translated into many Indigenous languages at this point, and they're all available electronically. They're on the website of the United Nations Permanent Forum on Indigenous Issues. And incorporating it into curriculum, both in the school systems within Indigenous communities, but also in non-Indigenous communities, for people to be aware of the Declaration and have that be part of our education system. And it can be used in policies and in decision-making. One of the things that's happening, I mean, one example of that is that the Assembly of First Nations, when they have their assemblies and they have resolutions, all of the AFN resolutions are prefaced by the relevant articles of the UN Declaration before they go into the resolution. And I know that the Union of BC Indian Chiefs also does that in their decision-making. So I think, and I'm sure there are others as well. So I think that that's a good use of using it in different kinds of governance and decision-making. And it also can be included in agreements with governments and corporations, and we know of First Nations that do that. It can be included in, you know, impact benefit agreements. It can be included in contribution agreements. You know, there's even something to the effect of, you know, we affirm the UN Declaration on the Rights of Indigenous Peoples as a umbrella statement to agreements. And I think that also, you know, discovering how it can be used in litigation, including in title cases. But it's also important that it's argued well. And one of the challenges, I mean, Paul spoke briefly to a couple of cases, and there's a lot of other examples of where it has been used in litigation, and which has been helpful to the First Nation client. There's also been a challenge where sometimes the client may ask for, oh, we want to include the declaration, and perhaps the lawyer isn't familiar with international law, so they'll throw it in, but they don't argue it and they don't defend it, and then that's not useful. So it is important that legal counsel make sure that they inform themselves on how best to use international law to support the domestic arguments. And it's also quite unacceptable for any government to refuse to engage with Indigenous peoples, like using that. We've had people contact us, oh, we were in negotiations with the feds or with the province, and they said we can't use the declaration. And that, you know, that's really not acceptable. We have a federal government that's made a major commitment to it, and provincial commitments have as well. But even if provincial governments don't make a commitment to it, when Canada endorsed this at the UN, they do that on behalf of the Federation. So that applies to all of them. So Ontario can't say, oh no, that's the feds. That's not when you're, international law doesn't work that way. If Canada's made a commitment internationally, it applies to the provinces. So I think that that's also important to not allow officials to try and introduce that you can't use it. And so that's the end of the first presentation. We wanted to leave a little bit of time for questions. Yes?
When Minister Bennett said that Section 35 is now a full box, how is that reconciled with the Living Tree Doctrine? That kind of concerns me, that statement that it's a full box. If the Living Tree Doctrine, you know, sort of speaks to the evolution of the Constitution, and it's a living document.
No, that's a good question. Actually, the reason they mentioned it's a full box is the position of successive federal governments was, yeah, you have Section 35, but it's an empty box. It doesn't include anything until we agree that it includes something. And so they made Indigenous peoples in every court case prove every single thing. You have to prove that you are an Indigenous people. They wouldn't even accept that. And what that meant is to create a huge cost for Indigenous peoples. If they ever go to court, they're going to pay dearly. And then the next time they'll be less eager to take, you know, to get into litigation. So that was what it meant. So what she was trying to say, and I don't believe necessarily they'll carry it out, and that's why it always takes, it's one thing for the government to take a new position, it's another thing to hold them to it. Because I'm not convinced yet that they will, in litigation or in negotiation, say, oh yeah, you have all the rights in the UN Declaration and it's in Section 35. That would mean they're all constitutionally protected. That raises your rights in the domestic context to the highest level. In addition, which you should always bring in, then the international law to make it even stronger. So I don't see it as that's really the context it's meant in. And actually the living tree means that what Bennett said is justified in the Constitution. Because the living tree means that yes, with this new instrument, it has support all over the world by consensus. It is part of the Canadian, the rights are part of the Canadian Constitution. So the two actually can go very well together.
So I listened to Hayden King this morning talk about the implementation of the rights framework and the watering down of FPIC in terms of consent. And then I'm wondering how then Bill C-262 will work within the rights implementation, as well as the recent decision by the Canadian government to not consult on lawmaking, and how UNDRIP and all of that feeds into these issues. So do you see that that's going to be problematic in some, like, especially with the rights, the implementation of the rights framework that seems to water down UNDRIP in a way?
So I think they are all interrelated for sure. I think that one of the things about the rights framework is that, and I may have different information than Hayden does, but I do not think something will be tabled in December. I think that First Nations leadership across the country basically told the feds, like, this is not happening. You know, that what the feds came out with in September was so bad, was that report was so bad, so weak, and they got told, yeah, this is not okay. And in fact, we were at the AFN meeting where they had a 2-day forum to talk about that. And Bennett got up and she gave this great speech. Well, it was good, right? She gave this good presentation on what we want this to be, which bore zero resemblance to the document that her department had released just days before, saying what, and that's what Hayden was speaking to, was that document. I think that document's dead in the water, that's my opinion. So I would say that they do need to reconcile themselves with political commitments that they have made. They've made these commitments to the UN Declaration. They've also made the commitment to Bill C-262. 262, as law, states that the UN Declaration has application in Canadian law. And they can't, there isn't, I mean, they can attempt to, or officials can attempt to water that down or domesticate it, but in law they cannot. I mean, it's very clear in law where the role of international law is, and the role of domestic law. And domestic law is meant to measure up, not measure, measure down. So I think that will be an ongoing evolution in terms of that. And I think that's one of the other reasons why 262 is so important, because then they've made these political commitments. 262 actually gives us a piece of law that is affirming those political commitments. And I think that, I mean, and Paul may want to speak to this, but I think, yeah, I mean, the recent Mikisew decision is kind of out in left field in this conversation.
I'm kind of concerned because it does, on your nice handouts here, you say, in other words, it says that the bill, C-262, will require the government to work with Indigenous peoples to review existing laws.
Yeah.
And bring forward reforms to ensure their consistency with the declaration.
Yeah.
But if they've already said, we don't have to consult with you regarding lawmaking, will that trump this statement from the bill? Or the purpose of the bill in that way,
Okay, let's go back to the first points you made, and then remind me if I don't cover everything. First of all, Hayden was right. The current government is saying in the 10 principles that it's not to free, prior, and informed consent. They're saying aim to secure consent. And we've noticed that. And the other thing is they talk about infringement of Indigenous peoples' rights. And the Supreme Court of Canada does use the word infringement, including in the recent Mikisew Cree case, which we did here. Now the thing is that one should never accept that document, the 10 principles. And anytime the government comes out with something, the first thing you want to do if you have concerns with it is say, what is the status of that document? So if you look at what the 10 principles are, they never consulted Indigenous peoples on it. They did it unilaterally. So that's the first thing you bring up with the government, that this has no validity. It goes against what you're saying generally about collaboration and working together. And so the other thing is Jody Wilson-Raybould, as the Minister of Justice and Attorney General of Canada, spoke in July 2017 at the AFN annual meeting in Regina. And in her speech, if you look it up or we can make it available, she says in it, these 10 principles are not really for the chiefs. It was just more for the bureaucracy. So she said that specifically. Now, this isn't well known, so I've seen now agreements being entered into where the government says some nice things in the agreement, but they also include the 10 principles, and unknowingly, First Nations involved thought, well, we have these principles, and some of them are good, they refer to the right of self-determination. But if there's stuff in there, like we're talking about, you should never agree to the 10 principles. It's not a valid document. It's unilateral. It goes against their positions. It goes against the UN Declaration, both in terms of consent and the principle of consultation and cooperation. And they should never affect your rights unilaterally. So that's what I would answer there. Now, the Mikisew Cree case, which came out recently, Mikisew Cree First Nation versus Canada, that's a real disaster, in my view. And first of all, it's a disaster because litigation, I'm not criticizing anyone, but I'm just stating fact. If you litigate a case, you always make sure that what you're asking for, the article, the law you rely upon is the right law. And what all the judges said in that case is, you used the wrong article. That act, the Federal Courts Act, does not apply to governments. It's more for tribunals and other federal bodies, but not the government itself. So right away they said, like Rosalie Abella wrote a dissenting opinion that had some good points, not all, but much better than what the majority said. And she said, how can you just wipe out the duty to consult? And how do you do that? You know, these are constitutionally protected rights. They use always the expression that Section 35 guarantees Indigenous peoples' rights. Guarantees. How's that a guarantee if now you say you don't even have to consult at all? And she said, and how did you wipe out the claim that the honor of the crown doesn't apply here in an enforceable way? So there are so many problems there. But you start with, and no one effectively brought up international law, because if you brought it up, it changes the debate. If you know what you're talking about, and most, from what I've seen, there are many lawyers representing Indigenous peoples aren't, as Jennifer said, familiar with this, what's happening at the international level, so they tend to stick with what they have, and that's a very narrow box, and it's out of date. And international law can be used to interpret Canada's constitution, as I've mentioned. So I just want to finish her part. The other thing is infringement. Infringement is, I've checked a whole list of key international human rights instruments, the most fundamental ones that exist, including the UN Declaration, the American Declaration on the Rights of Indigenous Peoples, the ILO Indigenous Peoples, and the Indigenous and Tribal Peoples Convention, the Universal Declaration of Human Rights. None of them allow infringements. None of them use that word infringements. You are allowed to limit human rights, because human rights, as Jennifer mentioned, they're generally relative. They can't be absolute. I'll give you just a fast example. In Quebec, when Quebec wanted to separate, and they held those two referendums, and the Premier said, not 1 inch of Quebec is going to stay, of the province of Quebec is going to stay when we secede. And that meant that all the Indigenous peoples, which is the areas they need for their hydro and mining, etc., 2/3 of Quebec, which is, Indigenous peoples have been there for, say, thousands of years, and Quebecers came 400 years ago, they would forcibly be taken with them. Well, if the right of self-determination of Quebecers was absolute, then they could do it. But that would also mean Indigenous peoples have an absolute right. So everyone can't have an absolute right going in different directions. That's why human rights has to be relative. And, so these things become really important to know what are human rights, how do you use them, how do you protect yourself against others. And this issue of infringement should be challenged, because even Abella used the word infringement. And it's nowhere in international human rights law. So I'll just leave it at that.
How about you?
What's that?
How about you challenge it?
Always, if you're challenging something new, just as a general rule, you pick the best possible fact situation you have. Never go to court with a lousy fact situation and hope to establish new precedents.
And I would say too, also just to Paul's comment about litigation and using the UN Declaration, The organization that I work for, we partnered up with Amnesty International, and we were interveners in the Tsilhqot'in Nation case. And what we argued, only at the Supreme Court level, so we weren't interveners until it reached the Supreme Court. And our application to be an intervener was based on that when the Supreme Court was doing that case, looking at did the Tsilhqot'in people have title to their land, that international law had to be used in making that decision. And so, and the way that it works at the Supreme Court, you have to apply. You can't just submit your argument. You have to say, this is the argument I'm going to make to the court. And so the court accepted us. They said, okay, you can make that intervention. And not only did they accept us, they said that we could make the written submission, but we could also have an oral argument. And so Paul was one of our lawyers, and we had, so that was our whole submission, was based on when the court is looking at the Tsilhqot'in case, international law needs to be factored in. And people may know that the Tsilhqot'in won that case. It's an enormous victory. It's a huge piece of jurisprudence. You know, as the law in this country evolves, that will be seen as a watershed case for Indigenous peoples. And so I think that, you know, when it's argued well, it is to the great advantage of Indigenous peoples.
There's one proviso I would put. It's not good, we did it then. See, to be an intervener, you can't argue something that the parties didn't argue. Some party had to have argued it. So we met with the Tsilhqot'in lawyer and we said, these are the words we need to put in our arguments. So they made sure those words were in so that we could make the argument, because you can't just bring up a new argument that will be thrown out. But I would suggest that it's not enough to do it only with interveners. Interveners aren't treated usually with the same amount of focus and strength as the parties. And if the parties would raise it, that would be better, and then you can bring in the interveners. Why the Tsilhqot'in case is really interesting was the first time, probably in Canada, but certainly in BC, where they first held a huge meeting with Indigenous peoples and non-Indigenous organizations like the Quakers and Amnesty and Hurricane from Quebec, etc. It was the first time they said, look, everyone, especially as interveners, you only get 10 pages and maybe 10 minutes if they let you speak at all. Let's divide up all the arguments so that we cover all of them. Because in 10 pages, you can't cover everything. So it was very coordinated, and everyone picked a different aspect, which made it a much stronger argument. So these are all litigation strategies, and they can be done better, and we can learn how to make it better.
Just spectacular work on both your work on this declaration. And you noted that for the first time, Indigenous peoples were able to participate in the declaration itself, the negotiations of that. Would you agree that that sets a precedent, that opens the door for Indigenous peoples to go to The Hague for violations of that?
It sets a precedent for sure. It sets a precedent in terms of the status that Indigenous peoples had in the development of the Declaration. One of the things that's happening right now at the UN is they're having discussions on changing the status for Indigenous peoples when they go to the United Nations. So right now, when Indigenous peoples go to the UN, they have to apply to go in as a non-governmental organization, which is the status that my organization has at the UN. And that doesn't make any sense. Indigenous peoples often are there as indigenous governments. They're representing their people. So having the same status as a non-governmental organization doesn't make sense. And so the UN has recognized this, and they are in the process of discussions on a new status that Indigenous peoples would have, which is a new level of participation for Indigenous peoples throughout the UN system. There's a handful of states that really don't want to see that happen. And I would have to say, happily, Canada's not one of them. Canada's actually one of the states that's been fighting for this. Canada has been really supportive of Indigenous peoples and acknowledging that Indigenous peoples should be able to attend the UN as the head of their own governments.
Well,
So will that have an if that is successful, will that have an implication at The Hague? I don't know.
well, but Indigenous peoples are sovereign individuals and not necessarily sovereign states. So this declaration seems to protect that. And thus, they should be able to exist. The UN finally notes that they exist, and they exist in their own culture. And that would seem to me to open the gate to the International Court of Justice at The Hague, for them to bring any grievances based upon that declaration. Doesn't that open the door?
Before I get to that final part you mentioned,
Oh, we're over time. Okay, go quick.
okay.
30 seconds.
Just what has happened, because it was such a great process, suddenly the UN looking at it, and they created the expert mechanism on the rights of Indigenous peoples. They put Indigenous peoples on as experts. They did the same with the UN Human Forum on Indigenous issues. What that's doing is Indigenous peoples are helping to create new jurisprudence at the international level. It's not just non-Indigenous peoples. That's huge. That again changes how all these perspectives are going on. Now, as far as The Hague is very conservative. They try and keep it to just the states. They've allowed sometimes for advisory opinions, which is different than litigating a certain issue, for certain international bodies to ask a question like they did in Are Nuclear Weapons Illegal, for example. But they're extremely closed. It was like that when Indigenous peoples came to the UN in the late 1970s. They were treated brutally. They didn't just open up the doors of the UN. So it was a battle to get to where it is now. It's going to be an even greater battle because the last bastion is The Hague. The Hague is where you have the International Court of Justice to hear those cases. Right now, Indigenous peoples do not have the status, and as I mentioned to you earlier, you find a friendly government because they can raise it. You could then litigate the case through that government. But,
The declaration says they are entitled to this justice, and then they say you can't come in, though?
I'm just saying, I'm just telling you that it's been an evolution, and it was a big thing to open the door, because in the 1920s, Descahe, the Haudenosaunee leader, went there and didn't get anywhere. So they've made progress, but it's really slow progress. So if you ask me for an opinion, I would hope and love if they just open the door. And I'm just warning you that they're pretty tight group.
Thank you.
I know we're running short time. I think it's very relevant to the conversation we have today on FPIC. And I'm glad you raised Tsilhqot'in. I think we'd all agree that it's a monumental case, but there's also a significant piece in it the court touched on in relation to consent, picked up where Justice O'Meara left off in the W and kind of crafted what they think consent looks like, at least in the context of Section 35. I'm wondering what your thoughts in terms of how that aligns with FPIC or how it doesn't align with that.
I think we're covering several of the provisions from Tsilhqot'in in the next
Yeah,
presentation.
can you ask the question as we go through it? Or
Yeah.
when
I
we
think,
get to go
it
through?
may get answered.
Okay.
But in any case, I'll speak with you in the break because
Yeah.
I'm not quite clear
Yeah, sure, no
what
worries.
you'd like.
Yeah.
And I think the FPIC one is in his same room, but right
Yeah.
after the coffee break.
Okay.